Greetings, everyone. I'm Trevor McShane. It's time for another episode of Tune In with Trevor. And our guest today is James Pacitti, who's an entertainment lawyer. Tell us what you do as an entertainment attorney.
As an entertainment attorney, my firm, the Pacitti Law Firm, located in Beverly Hills, we represent creatives across the board, which include writers, directors, actors, composers. We primarily represent producers and production companies in the development, finance, production, and distribution of independent TV and film content.
And are you what's called a production lawyer as well?
That is one of the hats I wear. Yes, a production lawyer. That's talking about that process I mentioned of development, production, distribution, and financing. When we are handling production legal, I do have the role as a production lawyer for those projects.
That means you handle the contracts for the writer, the director, the actors, and everybody else who's involved with the production, right?
Yes, and we paper the production, you could say. We make sure the production has all the agreements, consents, releases, everything it needs to demonstrate what's called chain of title, because you have to have what's called clean chain of title. And chain of title is simply a series of the documents and agreements necessary to demonstrate ownership of a particular project. It's so that way you can distribute it, because if you can't demonstrate that, you can't get errors and omissions insurance. And if you can't get errors and omissions insurance, which is also known as E&O, you can't get distribution, because no distributor is going to touch it. So it's very important that all those agreements are done, and that's what we do.
How do you charge for those? Is it hourly? Is it a percentage? Is it of the budget? Is it contingency?
That's a great question. And it sometimes varies, and it may depend on what the particular production wants, but most of the time it is a percentage of the budget. And what that percentage is, it can be anywhere from 1 to 3, falls closer to 1.5, 2, but that's a function of the nature of the project, because it's a very different project that has 6 actors at one location as opposed to a project that has 100 speaking parts in multiple locations. So that will determine what the fee is, and it's like I said, it's a percentage of the budget. And sometimes it actually goes down when the budget goes up. Because there's certain things we're going to do for any production, whether it's a $500,000 production or a $10 million production. But it is usually a fixed fee because they need to have budgetary certainty in the project.
And when do you get paid?
We get paid up front, just to make sure, because sometimes you have to, and that comes from experience too. Sometimes productions will go into pre-production, which is the time period where all these contracts are done before they go into principal photography. Sometimes they don't necessarily have all their money. Sometimes they're relying on loans for tax credits or such. So we get paid up front.
So when you have a motion picture that's going to go into production, how does the financing work?
Well, it depends. There's a lot of ways that independent films get financed. I can use an example of The Brutalist, which is a recent film Academy Award nominated and won for Best Actor. That was, first they sold pre-sale rights at the Toronto Film Festival in 2020. And that what it is that rights to certain territories are sold in advance. And it's a way that you can raise money. And then eventually A24 came in and got the distribution rights for America. So you can sometimes borrow against distribution contracts, so get some debt, and the debt can then be utilized to help raise equity financing. So usually it's a combination of debt and equity financing. Your typical independent financing is you'll get equity investors, which are often wealthy individuals who will give money to the production, and they, for certain terms, usually your typical is that they'll get 120% back of their investment. So if someone put in $1 million, they get 1.2 million back. And then there's a 50-50 split after that recoupment between the investors and the producers, though that's a typical deal, but every deal is different.
The investor always gets back first monies, is that right?
Well, first money between them and the producers, because part of what makes independent film so tricky in making money is how many people take their cut before it trickles down to the production and what's called a waterfall.
Let's talk about the legal requirements involved in raising money. Explain what has to be done to meet security requirements of the government.
Well, that's a great question, Trevor, and it's also one that it's important for anyone out there who's trying to raise money. They need to know implications that people don't realize that you're implicating state and federal securities laws. Whenever you get money from someone, and whether that person gets the money back is based on your efforts. In other words, they're passive and you're active. So in the context of a film, you have investors and producers. So one of there's agreements that should be done, very thorough agreements. And there's entire seminars on film financing, but just to bullet point it, it's about disclosure. You need to disclose everything that an investor reasonably would want to know. Basically, you have to tell them all the ways they're going to lose their money. Right. And that has to be very clear, because if you don't and things don't work out, which they more often than not don't with an independent film and many films in general, is that they're going to come back around, well, I didn't know that this is something that could happen. And that thing happened. You didn't disclose it to me. And now I'm going to sue.
So we have what's called as you know, I'm an entertainment lawyer too. We have what's called private placement memoranda.
Yep, subscription agreements, accredited investor questionnaires.
And do you write those up, or do you?
Yes, we prepare those. When we're unfortunately, a lot in the entertainment business, people want to do things fast and loose. And I will tell you, it's often penny wise, dollar foolish with attorneys, because they don't want to spend money on us. They want to spend money on what they think will be on the screen. And so we encourage that, you want to do all those agreements.
Can you tell us what the going rates are for a private placement memorandum?
Well, it depends on the complications of it. It's, on the low end because there's a private placement memorandum, which is a document that describes the potential investment in great detail. Talks about the producers, what they believe this project can do, and so forth. And so you have that. You have subscription agreements, accredited investor questionnaires. So it can be. It depends what firm you go to. 10 to 15,000 the low end. I've heard of some where they're 50,000 for big, complicated productions.
All right. And ordinarily, what happens is that a limited liability, an LLC, is set up.
Correct.
And the advantage of that is that the investor is not liable as a managing partner overall, and he may or she may lose his or her investment, but is not going to be liable for any production problems or litigation that comes along.
Yeah, that's right. If it's done properly, because what people don't realize, and I know that if an entity, you form an entity, but you don't follow the proper formalities of that entity's limited liability protection can be penetrated. So that is the purpose. Limited liability is also tax involvement, but it has to be done right.
All right, let's talk about warnings for investors when they're putting in. I'm going to put in $100,000. What do I need to ensure that I'm going to be getting a fair count and dealt with properly?
Well, there's a number of different things. Of course, your typical accounting rights, audit rights. If I'm representing investors, I would prefer that all the money be placed in a third-party escrow account until they receive full funding. Because what you're going to have is, say a production is trying to raise this much, but they're only getting to here. So they start spending some money maybe on development and maybe trying to attach actors or purchase a script, but they don't raise the rest of the money. Now what? Because they don't have enough to do it. So that's one thing. On behalf of investors, I want that protection. Then otherwise, you typically might want to have them engage a collection account manager down the road, because a collection account manager will handle all of the collections and disbursement of the collections.
So let's talk about two. Vintage is one, freeway is another.
Yeah.
And I can tell you, in my experience, I've had nothing but problems with investors when I come in later as a litigator, and they have no right to see the books and records whatsoever. And there is a collection account where the money comes in, but they're not participants in it. They don't get to see the accountings, and they have no rights of audit overall. So I'm giving some advice here simply to say that if you're going to put money in, number one rule is get audit rights. Number two rule is make sure you're on the collection account overall. Let's talk about other issues that may. First of all, do you see problems? Do you hear from investors who are saying, hey, what's going on? I have problems?
We have frequently been contacted after the fact, probably right before you get the call, is that they put this money in this film. They've stopped communicating with us. We're asking for reports. We're not getting them. And what we'll see, the investment agreement they got, and I use that term loosely, because you'll see all sorts of agreements that do not meet the standards that I would have for it. And you see, look, you don't have these rights. You just agreed to give money, and it's very fuzzy how you get paid back. There has to be absolutely crystal clear how you get paid back. And a lot of rights you said are essential.
All right, so number one rule is to find out in advance what's going on, how you're going to get paid, and don't enter into what's called an investment agreement. Enter into only LLCs should be utilized overall. I have a large practice in entertainment, and I'm almost jokingly but facetiously saying, has an independent film ever made money?
Occasionally. It is very daunting, and a lot has to do with, one is just, but right now, just talking about our current environment, you have so much clutter, and theatrical isn't what it used to be. You can get people to go to the cinema, but it's very tricky. It's kind of more complicated. And the problem is, it's not, just streaming. People think, oh, streaming is really the problem. What's being missed is that all of this other content out there that is created, whether it's YouTube or TikTok and such, because Gen Z, for example, those who were born from 97 to 2012, they don't identify with celebrities and Hollywood actors as much. They identify with creators, influencers. So you're competing with that too. So to punch through all that clutter, it's really tough.
I am a shrewd producer. How should I set up a deal so that I will get back end? As you know, for the streamers, ordinarily, Netflix had said it's a buyout. Yeah. There is no back end whatsoever. You get your fee and a profit that is calculated. They say you're going to get, and maybe you'll get some spiffs or bonuses if it gets a certain critical acclaim or certain box office in the theater or a certain amount of viewers. But if there's one constant in the entertainment industry, in fact, in the world, is that it's this change. Everything is changing all the time. So here we are today. Tell me how, if I was a clever individual, I could get a back end if my movie's a hit. That's the problem with the buyouts, is if you make a turkey, okay, that's just great. But if you have a hit, like the halcyon days of yesteryear, you're set in perpetuity and all of your children. What can you do?
Well, as an independent producer, you have to be thinking about distribution in development. That is crucial nowadays, and maybe even considering raising P&A funds, because what's happening is, because...
What's P&A?
Oh, P&A was what we call print and advertising, even though there's not much print anymore. It's still the term of art. So we're talking about P&A, that's just basically all the money that's spent to promote a film.
To market it.
Yeah, to market. It can be, now it's social media ads. You can still be billboards or ads in magazines or commercials, but just all the money that's spent to promote a film and create awareness so people show up. Okay,
so how am I going to make my money?
Well, it's never easy, because you got a couple paths. So you mentioned Netflix. So you can go to a streamer. Netflix is a little different, but you can go to them and have essentially what's changed is that you used to have number of windows, territories were divided up. Now they take worldwide rights, they get all the rights. It can be licensed for a period of time. Sometimes they'll buy it out. Buyouts aren't happening as much. It'd be worldwide licensing, and you get this amount, and that's it. It does fantastic, it does terrible, you get the same amount of money. But you want to talk about what's happening is some independent producers are taking control and doing self-distribution. I'm involved in a number of these, where you're dealing through a representative directly with the exhibitors. There are companies who will deal directly with the AMC, the Regal, the Cinemarks, and they will get your film in their theaters. And They're also then you have others who will deal directly with it's what you're talking about. Netflix is SVOD, subscription video on demand. You have TVOD, PVOD, premium video on demand, TVOD, television video on demand, and then you have AVOD, which is advertising video on demand. So you have all these ways you can try and monetize it. And the good thing about Control is you then are the one who is putting it on these various places, and you can try a maximum amount of monetization of it through every avenue available.
If you're going to go, well, you're talking about going to the theaters and doing direct, which is, I think, very innovative and interesting. What is the P&A? What are the P&A costs going to be, relatively speaking? I've heard of some, in traditional yesteryear, it was 2 to 3 times the budget.
Yeah, it varies. I mean, sometimes, you'll hear like a big tentpole film. And by tentpole film, we mean these big Hollywood movies, these $250, $350 million films where they'll spend about 50% of that on print advertising. So you have a $250 million budget and then another $150 million on P&A. And with P&A, it depends on the film. What's important for independent producers, when you need to know your audience, especially nowadays, because you need to know how they consume media, because theatrical will make no sense if your demographic, your target audience, doesn't really go to the theater. Maybe they skew a little bit older, and your film is the type that's not necessarily needed to be seen in theaters. Some movies really are better in theaters. Others, the experience is not that much different to go watch in your flat screen HD 70-inch TV at home. So, it really, it depends. And it's something that it has to be thought about from the outset.
I think would be fair to say, as a rule of thumb, the indie marketplace is about 20% of the overall motion picture industry?
Well, it depends how you define it. It's more, because, if it's anything but the members of the AMPTP, which is the Alliance of Motion Picture and Television Producers.
Paramount, Warner Brothers.
Yeah, Warner, yeah, exactly. Universal. Those are the ones that SAG and WJ struck against. And everybody else, which includes A24, which is a big company, Neon's a big company, Lion, and so forth. So it's any of those films. So it's a lot of films are independent. A lot go unseen, essentially. For example, I think there's 4,000 some odd submissions to Sundance feature films, and they end up 82 of them are in there. So it depends where you draw the line about what's included, because even ones you may never be aware of, there's thousands of them.
Let's talk about clauses in the contracts that you do for your clients. As you know, I do a lot of litigation in the indie film world. And one of the issues that we're looking at all the time when somebody comes to us is whether or not the prevailing party gets attorney's fees. Mm-hmm. What are the pros and cons? When do you ask for it, and when do you say?
Well,
no?
When I represent the producers or production company, we don't want that. We don't want attorney's fees because if we get in a dispute, and it's always about who's the 600-pound gorilla in a situation, because studios don't want those when they're dealing with talent, because then talent's looking at, okay, because then a lawyer maybe can take it on contingency if they really like it, knowing that we got attorney's fees and costs to kick in.
If it's a good case.
Yeah, it's a good case. Whereas if there's no method for it, that means an individual has to come up with $50,000, maybe more, with no ability to recoup it, and hope that the claim that they have is worth it and the time that it goes into it. So it really depends on whose side you're on.
All right. Another issue that I have in my practice is arbitration clauses. As you, I'm sure, know, all of the majors require arbitration with one particular company called JAMS if there's going to be a dispute down the line, which is problematic in part, large part, because of the cost involved. These arbitrators are charging $600 to $800 an hour, and I've had disputes where $150,000 was in dispute, and the arbitrator charged $50,000, and then on top of that, the lawyers are charging fees, and it doesn't make sense. What's your position on arbitration? I don't think it's a good thing for any small company or any individual.
Yeah, it's so true that there was so much drive to go to arbitration over the years because of ironically, that litigation was so expensive. That's what drove to it, because there was the idea of the simplicity of it, the more limited scope of discovery. And now, as you pointed out, it's basically just become a more expensive form of litigation that's private and confidential. And it's actually the bar of entry is higher than it is because a lawsuit.
Well, I'm saying if I'm an indie producer, I think I need to be wary of the costs for myself as well.
Absolutely.
Well, that about does it. Thank you for joining the Trevolution, and stay tuned for the next episode of Tuning with Trevor.